Hi, and welcome to another edition of Ask the Expert series videos. And today with me is my guest, Mr. Patrick Tan, who is the founder and CEO of Fortis Law Corporation. He is a practicing lawyer who specializes in private client work such as trust, estate planning, wills and probate, real estate and family law. And over the past 2 decades, Patrick has assisted many families and individuals, both locally and internationally, with their private legal needs. In 2021, Patrick, who is also a registered trust and estate practitioner with STEP, STEP, is nominated as a finalist in the People's Choice Trusted Advisor of the Year category at the International STEP Private Client Awards 2021-2022. Patrick, welcome to Ask the Experts. Today, you are the expert.
Thank you, Parson, for inviting me here, and thank you for the very kind introduction. Hello, everyone.
You're most welcome. Thank you for taking the time to come and share what you do. So first of all, you are a lawyer, so you started this law firm called Fortis Law, but I heard from you that 1 year later, you started another company, Fortis Wills. Can you tell us about this company and why did you start it?
Sure. If we all remember, 2003 was the SARS period, that was when SARS first happened. So I chose really a weird time to start a law firm, if you were to ask me. So of course, business was tough. And so I was trying to find more work for myself. And then I realized that actually will is an area, or estate planning is an area that not many people in Singapore actually knew about it. And I realized the reason why was because making a will was relatively expensive at that time. So then I thought about making wills affordable. That was why 1 year later, I decided to set up Fortis Wills. Being a non-law firm, as an estate planning company that can provide affordable will writing services to the public. Why? Because as a non-law firm, I could actually staff non-lawyers to run the company. And if they are staffed by non-lawyers, then of course we can actually keep the cost low. And that is how we were able to actually make it affordable for many people. That was really the reason why I set up Fortis Wills in 2004.
Wow, 2004, that was quite some time ago, right? So I'm sure this company has helped many people write their wills and many other things.
Yes, about
how many people have you helped?
32,000.
Wow, 32,000. Yeah. Okay. All right. Now, yeah, it's a big number. Of course, there are still many more who have probably not come to you, or maybe they have gone to other companies. But can you help me understand why is it important to make a will?
Okay, making a will is important. Why? Because when we pass away, all our hard-earned money, our asset would be passed down to our loved ones. And making a will helps us to achieve that purpose. Because in Singapore, if we do not have a will, then our hard-earned money, our assets would be passed down in accordance with the law. So in Singapore, we have a law called the Intestate Succession Act. This law basically tells us how our hard-earned money will be administered or passed down, right? We do not have a choice, right? So the law doesn't take into account who is more important or who is filial to you, who do you love, or who do you want to give more to. So in this law, there is a formula and you do not have a choice. And I know that many people actually do not wish to follow the formula in the law. Being these assets are their own assets. They wanted to have a say in how these assets get passed down. So one way of doing that is to have a will, right? So many clients are making their wills nowadays because they realize it is important for them to decide how their hard-earned money and assets get passed down instead of letting the law decide for them. Because if you were to let the law decide for them, there may be unhappiness or misunderstanding among your loved ones when you're no longer around, and they do not want that.
I'm sure in the minds of many people, they might be thinking or have the impression that, writing a will, okay, is how you want your money and your wealth to be distributed among your, siblings or family or children. But what if I don't have a lot of money? Do I still need a will?
Yes.
What would you say to that?
A lot of people, yeah, they ask me over the years that, making the will is for the rich and famous, right, Patrick? I say that is not true. There's no law in Singapore that says that you need to be wealthy or very famous or before you can make a will. There's no such law. And we believe that everyone deserves to make a will. Everyone deserves to leave their asset to their loved ones with dignity, right? And no matter how rich or how poor you think you are, it is important to have a will. And all the more so, I always tell people, if you don't think you have a lot of asset, it is even more important that you have a will, because every cent counts. You need to plan properly. As compared to if you're very wealthy, then maybe you can be a bit more frivolous or, in your plan. But if you have limited asset, I would say, then it becomes important to plan properly, to make sure that all your hard-earned money, goes to the person whom you want it to go to.
Yeah, I guess for most Singaporeans, it is the HDB flat that is correct. The greatest value, I guess.
Yes, and we all know that HDB flat now is, can fetch a very high value. The prices have gone up tremendously compared to the past. And many Singaporeans own HDB flats. And HDB flat is a substantial asset that can be willed.
So what can happen if a person passes away without a will?
Yeah, so as I said earlier, if a person were to pass away without a will, first and foremost, the estate, the assets, would have to be distributed in accordance with the law. Now, that may not be in accordance with the wishes of the deceased person. All right. And secondly, the procedures involved in unlocking the asset, is tedious and costly. The next of kin would have to get a lawyer to apply for this court order and pay high legal fee in order to unlock these assets. So, and not to mention that there may be potential disputes among the loved ones. For example, if one of the children, the one looking after the deceased parent, and he would probably feel unfair if the asset were to be divided equally among his siblings, because that is the law, right? If the parent were to pass away without a will, half of it will go to his surviving spouse and the other half will be divided amongst his children equally. And that may not be what your children had in mind, right? And as parents, we certainly do not want that to happen.
Okay, so it could potentially prevent these kind of disputes, and squabbles, right? Because it came directly from that person, like let's say a father, okay? The father, so the will is basically the father's expressed desire, right, of how all his assets and wealth should be divided, and maybe he might even state the reason why. And so everybody understands, okay, yeah, so yeah, this is what he wanted. So it's not left to imagination, speculation, and things like that. So
that's right.
Although I guess it's not even foolproof, because when people are dissatisfied, they will still want to somehow fight for it.
Yes, of course, having a will doesn't guarantee that, your loved ones cannot fight over it, but it makes it so much harder, especially if the will is done properly and professionally. It makes it really hard for anyone to want to challenge it.
So the will writing company, basically their role is to help the individual in putting down on paper in a legally acceptable form all his or her wishes about how he wants, to handle or distribute, share his assets and wealth, right? So the person in the company will help to write that. Maybe it's even a kind of a standard template that can be used, unless there are some special situations or special way or very unusual way that the person wants to, deal with his wealth. Am I right?
Yes. So in the company, right, they work in teams. So we have estate planner and we have will writers. So estate planner, right, they will basically advise the individual, on what is involved in this whole process, to make sure that the individual understands. And in that process, right, I find that many individuals actually do not understand what actually comes under their estate, because in their mind they thought that they had all these assets, but actually they might not have all these assets. So it is important for estate planner to take the individual through this process to make sure that they understand what is involved, and to also ensure that their wishes and intentions can be carried out before we actually translate them into a will, right? So there will be this process.
I see. Okay. So it's useful also to help the individual, like me, for example, if I go to any of these will writing companies, firstly, I will have clarity on what actually, comes under the wealth or assets or things like that, and
That's
what
right.
I am able to do and what I have no power to do anything about it and things like that.
Yes.
All right. So is it a very long and tedious process?
No, actually, for us, because we have done this for so many years, we have actually fine-tuned the process. So all it takes is maybe an hour or less, we can have the will done up. Yeah, in some cases, we might need another session, but in most cases, I think less than an hour, we would have the will done up. Yeah.
Wow, that sounds really easy. We are definitely in the age of the instant, right? Instant noodles, instant coffee, and now we have almost instant will, right?
Yes.
Okay. Now, besides wills, the company also helps people with something else called the lasting
LPA.
power of attorney, LPA. That's right. Can you explain what that is and how different is it from the will?
Yes, LPA is actually a different legal document from a will. It is a very important document also. Basically, this is a legal document that allows us to appoint this trusted person called a donee, right, to make certain important decisions on your behalf when you lose mental capacity due to whatever medical condition, and the ability to manage your own affairs. So you have not passed away yet, but yet you are medically unwell. You are very ill, that you're no longer able to look after yourself. So during this period of time, right, you need somebody you trust to look after you, to make certain important decisions for you. So this LPA would give this person the authority, right, to make these decisions for you. So it is an entirely different document from a will, which comes in after you have passed away, whereas an LPA comes in before you passed away. So these two legal documents cover different stages of your life, if I may say that.
I see. Yeah. So let's say you're incapacitated due to a stroke, due to maybe a serious car accident, and you are not able to make certain decisions. So you have already thought about who you trust and is able to make decisions that are in line with your interests, right?
In your best interest.
In your best interest, that's right. Okay, I can see how important it is, because life has to go on, isn't it?
Yeah, because statistics have shown that, most Singaporeans, right, more than 70% do not go in our sleep, right? We would become ill, very ill, and before we go. So during this period of time when we are very sick, right, we need somebody to help us, like go to our bank, maybe withdraw money, to pay for our medical bills, to decide on which hospital to go to, what kind of medical treatment to receive, or even rent out our property or sell our HDB to raise the money to pay for our medical bill. So all this require a legal document to allow this person to transact or to do on our behalf. And just because we are married or we have children, it does not give them the legal authority to be doing all these things for us. A lot of people have this misconception that, my wife can do all this, or my son or daughter cannot do all this. They can't. In law, for example, your wife cannot sell your HDB flat without your signature, because the flat is in both names. So under these circumstances, you will need a court order, right, called a deputyship if there is no LPA. And that deputyship application can be costly, because you need to get a lawyer to make the application in court. It can take up to 6 to 8 months. So, but with an LPA, your family does not need to apply for any court order. With the LPA, the moment you lose mental capacity, your donee can transact on your behalf straight away, can get an agent to sell your flat straight away, can go to your bank and withdraw money without the need of any court order. So it is a very efficient and powerful document to have.
Wow. So it's crucial to pick the right person.
Yes.
Any advice, any kind of, guidelines based on your experience?
Yes.
How would one person choose the right one?
Okay, all my clients would pick either the spouse or children or parents to be their donee. Although legally you can pick a friend, a person who is not related to you, as long as this person is above the age of 21, cannot be a bankrupt. And to me, most importantly, is someone who knows you well, who loves you a lot, who knows your needs. These are the primary but yet important considerations to take into account when deciding on who to pick as your donee. And of course, your donee has to consent as well. We cannot force somebody to be your donee. So in order for a LPA to be registered, both yourself and your donee would need to sign the form and thereafter to have this form registered with the Office of Public Guardian. Now, registration takes a couple of months now. Once it is registered, the form becomes effective. All right.
Okay. Wow. This whole mechanism has really been refined and simplified right now. So it's not a hassle to do it, but it is important,
yes,
right?
It is.
And therefore, you want to make it easy for people to be able to do it and affordably also.
Yes, and our government has waived registration fee for all Singaporeans. So they used to charge $75 for registration, and now to encourage more Singaporeans to register the LPA, the government has waived this $75 registration fee. Right. So last year, I think more than 30,000 Singaporeans have registered their LPA already.
Wow. All right. That's good news.
Yes.
There's one more thing. Besides the will, besides the LPA, there's also something called the Advanced Medical Directive. Can you tell us what that is?
Okay, AMD is also a legal document now. As wide-ranging as the LPA is, LPA allows your donee to make wide-ranging type of decisions for you, but there's one type of decision that your donee cannot do, which is life and death decisions. Now, in Singapore, it is illegal to perform euthanasia, unlike in Switzerland or in certain states in the US where euthanasia is permitted. In Singapore, it is illegal. But what is legal is Advanced Medical Directive, in short AMD. And this is a legal document to allow you not to use any life-sustaining treatment to prolong your life in the event that you are terminally ill, unconscious, where death is imminent under our AMD Act. Right? So this is the law that says that if you do not want any life-sustaining treatment, right, then this is the form to fill up to register it with the Ministry of Health. So when you are at this stage where death is imminent, then the healthcare professionals can actually extract this form from MOH, talk to your family about it, and let them know that actually your dad or your mom, has done the AMD, and basically he or she does not want to prolong their life with because it can be costly. Life-sustaining treatment is not cheap, right? And so with that AMD, hopefully the family can make an informed decision, right? It is all about respecting the person making the AMD, because this person has made it clear that he or she does not want their lives to be prolonged artificially. So with that information, hopefully the next of kin can make an informed decision and bring this person home, right? Instead of keeping this person in the hospital and prolong the life after.
Yeah, and incurring the daily, hospitalization costs, medication, treatments, and all that. Right. Wow. Okay. Now, I can also imagine that just talking or even thinking about these three different documents, and just thinking about them, a lot of people might feel uncomfortable, right? Because it has to do with sickness, and and we're not talking about cough and cold. We're talking about chronic, even terminal diseases, and which leads to death and death itself. So a lot of people find that, hey, this is taboo. I don't want to think about it right now. I'm still healthy, right? Why should I think about it? I'm sure you've come across, these kind of mindsets.
Yes.
What do you say to them?
Yes, definitely. I've come across, many people with this kind of mindset, and I can totally understand why, they feel that it is such an uncomfortable topic to discuss. But I would always tell them, yet it is so important that you have to confront it. You have to talk about it, because never assume you know, that your loved ones know, you know, what you have in mind when it comes to, you know, how you wish to be cared for. I mean, personally, I've gone through this myself with my family. You know, before my father died in 2013, he spent a year in an SGH. He did not have any of these documents done up. So my entire family went through this whole process with my father, and it doesn't just affect him. It affected his whole family as well. We would be in the hospital visiting my dad every day, right? And halfway through the stay, he basically lost all consciousness, right? His system was shutting down, and he did not do an AMD. So when the doctor suggested to the family to bring my father home, where they would prescribe some morphine to ease his pain and suggested to us to let him go, I mean, we were in shock. We were in shock. And by the time it was too late for us to even ask our dad, you know, what he feels like, because he couldn't talk anymore. So can you imagine at that stage, you know, how do you expect your children to make this kind of decision to end your life? It wasn't an easy decision to make at all. And because of that, we kept our father in the hospital for another 7 months. And I paid, I think, another $170 over $1,000 just to keep him there. Pray for a miracle, which never came. And he succumbed to his illness later. I mean, half a year later. So basically, it affected the whole family. So I could totally understand. So whenever I meet people who are resistant to the whole idea, I say that it is important, because if you love your family, if you do not want to put your family, your loved ones through this whole process, you have to talk about it. You have to talk to them about it, and you have to make a decision to get all these things done, right? Otherwise, it is not you who is affected. It's the whole family, your children, your spouse, your loved ones. And I'm sure many people agree that we will not want to put them in this situation.
Yeah, because by the time those things happen, you are probably not in a position, not in the state of mind or body to explain things to them, to, you know, help them through it, right? And they have to wrestle with it all by themselves. And yeah, sometimes that's that sense of, you know, filial piety, loyalty and all that, right? You know, like, thanks for sharing your story. I think this is really, really close to your heart. And it makes things very clear. This can happen. In fact, I'm sure you agree, this is probably happened over and over and over again.
All the time. In the hospitals, you know, if you were to visit, then you see families quarreling outside the ward, always over these matters.
Correct. So it's better to make your wishes known clearly, legally, so that, you know, people will feel set free. I guess that's a good word, right? Set free. Because I don't have to make the decision and live with that decision, right? And regret, maybe I shouldn't have decided, maybe I should. I think that's really, really torturing for whoever is the one making a decision. Could be your spouse, could be your eldest son, you know, or anyone, right? That I can't imagine how, you know, to live through your life, having to bear that burden. Wow.
Absolutely right, Parkson.
Yeah, it really makes sense. Okay. So we have the will, we have the LPA
and the AMD,
lasting power of attorney, and the MDA. Three very important documents, and it's easily done, very quickly done, and they are all affordable because the government and people like you, Patrick, you know, is encouraging people, and with your own personal story, you're telling people, hey, don't avoid it, all right? Don't run away from it, because this is going to help your family when anything happens.
That's right.
All right.
Absolutely.
Any last words from you, Patrick?
Please do not procrastinate. These are important documents. It is not as complicated or as costly as you might think. We never know when we will fall sick or when our time will come. And remember, we are not doing this for ourselves. We are doing all this for our loved ones, for our family. So please go and have these documents done as soon as you can.
All right. Thank you very much, Patrick. And thank you for your time today, for sharing with us about this very, very important aspect of our lives.
You're welcome, Parkson. Thank you very much.